Hi, everybody. I want to get started. If I don't get started now, I get in trouble with the people in the back. I'm Josh Long with SupplySide. It's great to see everybody here. We don't have much to discuss today. There's not much going on in the world, but we'll try to get through these next 59 minutes. Before I start, I just want our distinguished guests to introduce themselves for 15 seconds.
Kyle Turk, Vice President of Government Affairs for the Natural Products Association.
Randall Mondry. I'm a partner in the Washington, D.C. office of Amin Wasserman Gurnani and co-chair of the FDA and Regulatory Practice Group.
Robert Marriott, Director of Regulatory Affairs for the American Herbal Products Association.
Thanks for coming, guys. We'll see you next time. I'm Josh Long, Associate Editorial Director with SupplySide Supplement Journal. We'll get started here. Event information. I'm not going to read that. You guys can read, I hope. We'll go on here. We prepared these slides 3 weeks ago. There have been a few developments since then, apparently. So this is what was on our radar at that time, you know, the MAHA movement, and this statement from the Trump administration. But that's really not where this conversation is going to go, I don't think. This is what we're going to talk about. Rapid pace and implications of legislation across the U.S. states, the Trump administration, RFK Jr., FDA under Dr. Marty Makary, opportunities and risks for the supplement industry under the Republican-controlled 119th Congress. Kyle, I don't know what happened to the next question. I'm gonna turn it over to Kyle Turk to talk about the Trump administration.
I think that's me.
Oh, Rand, I'm sorry.
Do you want me to grab this? Okay. So I guess I don't need this. I'm going to go here. All right. I think I need to go backwards a little bit. Okay. There we go. All right. Well, thanks for that initial poll. I think that was kind of helpful in setting up some of the comments that I'm going to be making. I'm going to go through things pretty quickly. I think I just have about 10 minutes, maybe 6, I'm not sure, depending on this timer here. But going to go over some of the notable presidential actions as well as some federal agency and updates. So first, I can tell by this poll, this is, I think, kind of how we're all feeling at any given time, confused, befuddled, just trying to figure out what does all of this activity mean. Hopefully we can help get to the bottom of some of this, but I think it is pretty early to tell, and there's going to be a lot more to decipher over the next few months. So just a brief timeline here. There have been, and as of April 2nd, 103 executive orders that have been signed so far this year. The first one was a memo that came out, and this is typical of incoming administrations where there is a regulatory freeze on rules and regulations and guidance documents pending a review by the new administration. And then we saw this unleashing prosperity through deregulation. I think that's a great name. And this is basically the 10-to-1 rule for every 10, for every one new rule, regulation, or guidance document, there needs to be 10 that are rescinded. So that will be interesting to see how that is implemented. Because we do have a lot of important rules and guidance documents for this industry. I think there are still portions of the revised NDI guidance that need to be finalized. So what will come and what will go remains to be seen. And then we have the establishing the Make America Healthy Again Commission, the MAHA Commission. And if you've taken a look at that, really that focuses on addressing the root cause of chronic disease and creating a commission, a multi-agency commission that would look at these issues. Looking at chemicals in food is another key aspect of MAHA. And then we have this ensuring accountability for all agencies, and really what that's aimed at, and it's really somewhat unprecedented, is looking at independent agencies like the Federal Trade Commission and SEC, and having their significant regulatory actions be reviewed by the administration. And this is in response to what the administration has called sort of stemming the tide of the rising administrative state. So that is something else that we are watching for, and what types of FTC actions are going to be reviewed by the administration. And then finally, and actually this started with DOGE actually back in January, on January 20th, this Department of Government Efficiency, and that led to obviously several employees, including at FDA, being let go, and other restructuring over at HHS. And so that's still unfolding, but that's something we're obviously watching very closely. And it was a busy January for FDA prior to this regulatory freeze. I'm not going to go through all of these, but there were a number of significant actions, and for the most part, these are all still in place. There were some extensions of the effective date, including for the healthy rule, but that is still going to be, the effective date hasn't changed. It was, I'm sorry, the date at which companies need to update their labeling and their claims, that hasn't changed in terms of that 2028 date, but just the effective date of the actual rule was delayed. And that was for a few actions, and this was not just within FDA, this is obviously other agencies too, like USDA, where that was delayed effective date. So moving on to just talking a little bit about HHS, I think many of you are already familiar with some of the statements from RFK Jr., particularly around this MAHA movement. And really a focus has been looking at ultra-processed foods. Robert and I were just talking about that earlier, sort of an undefined, vague concept. What is a UPF? That doesn't seem to be any regulatory consensus or scientific consensus on what that is, but it's obviously a focus, as well as removing chemicals in food. And FDA has already gotten started with some of that process, with brominated vegetable oil and a few other substances too that FDA has been reviewing. But it's this message of fixing the food supply, addressing highly processed foods. And what's interesting, if you look at dietary supplements, those are pretty highly processed, right? And could those be considered an ultra-processed food? Potentially. Obviously, there's a lot of opportunity within this administration and recognition that there's different ways to look at treatment of disease, and additional ways to look at how to improve the health of the nation, including children. And certainly there seems like there's a role for dietary supplements in there, but when you also look at the message of, rallying against food chemicals and ultra-processed foods, where do dietary supplements fit into all of that? That's a big question for me, and something I think the industry needs to vigilantly watch. Another big announcement on March 10th was this proposal by RFK Jr. to eliminate the self-affirmed GRAS pathway, which would be huge for the dietary supplement industry if something like that were to go forward. But I think there's no reason to panic at this time. I think there's a lot of questions that need to be answered. What would the scope be? Would it be retroactive? How would it be prioritized? So I think for now, I think it's worth looking through your ingredients, looking at your safety dossiers, just being prepared and being informed. But we don't see a reason yet to have a complete change in what you're doing in terms of reviewing the regulatory status of ingredients and moving forward. The announcement did acknowledge that there would be a potential role for Congress to pass legislation that would remove that self-affirmed GRAS pathway, because there is a court case that did recognize the validity of self-affirmed GRAS, and where the court concluded that essentially there would need to be an act of Congress to remove that pathway. And then also a subsequent rulemaking, as I mentioned, with this 10-to-1 initiative in place, what 10 guidance documents or rules of regulation would be rescinded in order to move forward this rulemaking to remove the self-affirmed GRAS pathway. And then after that, and I think, I haven't heard anything recently, but there were reports of RFK Jr. meeting with members of the food industry to talk about some of his initiatives. So in terms of recent HHS and FDA updates, they've been pretty minimal given this new transition for a new FDA with the commissioner recently being sworn in. But in March, we did see HHS and FDA together announce this chemical contaminants transparency tool, which is basically just a database of action limits for various contaminants. I'm not really sure how this tool is intended to be used. I guess it's for use by industry. Kind of sounded like it was for consumers, but if you look at it, really not consumer friendly. And you'll see this theme of transparency keeps coming up again and again and again. So we'll see how that plays out. And then there was also this Operation Stork Speed to expand options for infant formula. Obviously, was a result of the infant formula crisis previously, and making sure that there is a continuous supply of healthy and nutritious infant formula. And then we had this, as I mentioned, as part of DOGE, this restructuring of HHS, consolidation of workforce, creating and removing divisions, and including the creation of this Administration for Healthy America. I guess that's AHA, if we want to call it that. And this is, again, really tied to ending chronic disease through safe and healthy food. That is the stated mission, and addressing the root cause of disease, and also removing environmental toxins. And then last week, we heard that as many as 10,000 staffers across HHS, including officials at FDA, received these RIF notices. I did see some news recently indicating that maybe some of those were issued in error. Still figuring that all out, not really sure who's staying, who's going, and possibly some of these employees would be brought back in June. In total, it looks like FDA would lose about 3,500 employees. As I mentioned, possible rehiring, and there have been concerns about a brain drain and really having these well-qualified experts at FDA no longer there. So it really does raise questions. How are all of these initiatives going to be implemented when we don't have the right staff there at FDA to be able to carry that out? And now moving to Marty McCary, a little bit about his background here. And in his first speech, which I listened to twice, it was issued last week, I believe, to FDA employees. Is that right, Josh? Yeah, and it was very interesting. I think what I noticed from it was that it really repeated some of these themes that we're hearing out of RFK Jr. and HHS. Radical transparency, I think that was said at least twice. We're hearing talk of, again, looking at the root cause of disease, looking at the cause of autism in children, increase in food allergies, autoimmune disorders, and really, what struck me was the questioning of the treatment and diagnosis by healthcare professionals. That is not something that has traditionally been in the purview of FDA, really the practice of medicine and questioning those practices. I mean, certainly accelerating new products, new therapeutic applications, all of that is within FDA's purview, but there was really I would say, a very harsh look at some of the well-known and well-established treatments that have existed and whether those were being overprescribed. There was a lot of talk about the opioid crisis and how the medical community got that wrong. And discussions of topics like, we need to have humility in science, we need to question assumptions, all of this. So really, I don't know what that means moving forward. Do we see an opportunity for dietary supplements? Possibly. But there was also a lot of talk about science, and we need the right science. We need to question the science. Well, who's going to do that if we don't have the right people there? There is this, what we're hearing, this theme of tearing everything down and rebuilding it, but who is going to be serving in those roles when we rebuild? Who are those scientists? I think there's a lot of questions that we have. I think moving forward over the next couple months, hopefully we'll have some answers to these questions. I'm going to go really quickly on FTC, not too much. I have some information on some of the new leadership over at the Bureau of Consumer Protection from what we know about the new director of BCP. He has a background in financial fraud and financial issues. We're expecting this FTC to look at more traditional fraud like previous Republican administrations, protecting children online, things like that. So I don't know that we're going to see anything really shocking out of FTC, whether or not there's going to be a focus on dietary supplements and food and misleading claims, things like that, remains to be seen. Updates to the green guides and the guides covering environmental claims, that was a big initiative that FTC had announced. We don't know whether that's going to proceed. I would not be surprised if it didn't proceed. And then last month, Trump had fired the 2 Democratic commissioners that were serving on the 5-member commission. So as far as I know, we now only have 3 commissioners. And finally, just leave you with something, I guess, lighthearted. We had last week, Trump had welcomed Kid Rock to the White House to talk about junk fees. And this is an FTC rule. They're calling it kind of this rare bipartisan moment, if you will. The previous administration had pushed forward this rule prohibiting junk fees, those annoying fees they tack on once you're going through the checkout process, and then you're like, oh, here's an extra $100. Well, it's affecting all types of products, supplements, but also, in this case, it had to do with Ticketmaster and those types of fees that you get from these more so ticket scalpers. And so, we expect this type of actions by the FTC to obviously gain attention moving forward. And then finally, I'll just do a plug for our regulatory roundup that our firm puts out. It's pretty much every other Tuesday where we have just brief updates on the topics that I just talked about, as well as FDA, FTC, state updates, and class action litigation updates. All right.
Hey everyone, it's good to be here. My name's Kyle Turk, Vice President of Government Affairs for the Natural Products Association. We're going to be talking about Congress and kind of how we got here. Not a lot to talk about, as you could imagine. So Election Day 2024 was a huge night for the Republican Party. Not only did they hold their majority in the United States House of Representatives, but they also won enough seats in places like Montana, West Virginia, and Pennsylvania to take control of the United States Senate. Obviously, Trump had also won the White House, but equally important is at the state level, they expanded their majorities in places like New Hampshire, flipping the Pennsylvania State House, flipping the State House in Minnesota, Michigan, and even having a net gain of legislative seats in a place like California. So ultimately, for the Republican Party, this was an opportunity that they pounced on, and for them, both at the federal and the state level, they're looking at this as a mandate for them to grow the economy, streamline regulation, and secure the border. So currently in Congress right now, we're going through the reconciliation process and the budget. So what that means is both the House and the Senate are looking at rules for how they will fund the federal government next year. Earlier in the year, they had passed a short-term CR that basically gave them enough runway to fund the government up until the end of the spring, really. And both Leader Thune and Speaker Johnson have set the goal for presenting something to President Trump by the end of Q3, ideally right around Memorial Day weekend. So how does this impact the dietary supplement industry? Well, once they get through the reconciliation process for this current year, now they can turn to FY26. And there are a number of priorities, not only for our association, but the industry at large, to be a part of that policy-making process. One of the, I think, biggest things for the industry would be expanding access to dietary supplements through HSA FSAs. These are conversations that we're going to be having and already have had with leadership to include this in the budget for FY26, so that way you all can have access to sell your products to consumers through places that reimburse through HSA, FSA. Additionally, things like SNAP and WIC are going to be critically important to committees such as the Senate Finance Committee, Senate Committee on Aging, House Ways and Means. So there are a number of different opportunities for the industry to partake not only in the policymaking process for individual pieces of legislation, but then tie them onto bigger packages that we know we're going to advance just because, quite frankly, they have to. So as of right now, those are a couple of the things that industry trade groups are working to present to congressional leadership and kind of see where it goes. But as of right now, they have to go through conference committees to get FY25 up and running. Now the fun part, tariffs. So as you all know, on April 2nd, he announced his tariff policy, Liberation Day, as the president's calling it. And I think for industry, we need to start looking at this as an economic driver for the industry right now. We were, quite frankly, grateful to the president that there were a number of exemptions included for a number of different reasons. Primarily, our industry is succinctly aligned with the Make America Healthy Again initiative that is going through HHS. And the president and the administration have acknowledged that through not only the tariffs, but then also some of the legislative priorities that they're pushing through MAHA. So when we surveyed our members, we found over 50 HTS codes that were going to be affected by tariffs. We met with congressional leaders, we met with the administration, and as of right now, there are a number of key ingredients to industry that are excluded from the tariff process, and we're going to have another bite at the apple. There's the Section 301 exclusion process where we can partake in public comment, and we're also going to continue to work with the administration to identify key areas for industry that were currently not in this first tranche of tariffs. I think one of the things too that sometimes gets lost in the shuffle with all of this is in the first Trump administration, the president recognized the importance of the dietary supplement industry as a critical workforce infrastructure. And what did that mean back during COVID? Well, it meant a lot of the manufacturing that was done here in the United States would be able to stay open during COVID. And that goes back to the MAHA initiative. It ties in well with this. So in terms of economic growth, there's a lot that can be done moving forward, not just for this year, but for the next 3 years as well. And then there's tying in DOGE and MAHA, and where do we all kind of fit in on this? Dr. McCary, during his confirmation hearing, committed to taking an undertaking to review the FDA and the assessment of staffing. As we know, there have been staff layoffs. There have been people that have been brought back, and we expect that there will be additional people that brought back. I think, generally speaking, if you've been following politics for the last, 18 months, this should come as no surprise that there were layoffs across the board. This is something that the president, his cabinet have been campaigning on, and it's been a clear directive that they're going to restructure the government. And as Josh and I were talking about last night, there is even an announcement to restructure FDA again. While sources were anonymous, there's going to be more information to come out over the next couple of weeks as far as what does that reorganization look like. But more importantly, looking at the MAHA goals, right? One of the things Secretary Kennedy has talked about is direct-to-consumer advertising for pharmaceuticals. Frankly speaking, a lot of our industry stakeholders aren't able to make the same communications to consumers despite all the research and development that goes into bringing world-class products to the market. If they're going to continue to talk about direct-to-consumer, that opens up an opportunity for us to work with both the administration and Congress to say, hey, how do we expand claims for our products? Because for so long, the pharmaceutical industry has had a stranglehold on how they can communicate with with consumers. And then finally, too, Secretary Kennedy has talked about a self-GRAS process. What does that look like, and how do we restructure that? Still in the infancy stages of that, but something that we're all closely monitoring. And then MPA priorities for the 119th Congress, and how does the industry tie into all this? I think between tariffs and Congress's goal to bring manufacturing back to the United States, this is a can't-miss opportunity for all of us to be a part of the conversation, whether it's talking about tax incentives, depreciation expenses being wiped off. There are a number of different avenues that we can take from a congressional standpoint to have our message heard when it comes to how we bring manufacturing back to the United States and really strengthening the supply chain. The House Ways and Means has a tax committee that is specializing in manufacturing, and we've been working closely with that team to communicate all the benefits of the dietary supplement industry and how we can explore opportunities legislatively to bring manufacturing back to the United States. HSA FSAs, as I explained earlier, this is a can't-miss opportunity for us. I think we'll have really one crack at this when it comes to reconciliation and the budget. As it stands right now, Senator Kramer and Representative LaHood have a proposal in that would include NIH-recognized essential nutrients along with botanicals and probiotics. And where that proposal is right now is with a committee on joint taxation. They're exploring it to look at the score and how it would impact the bottom line for the federal budget. And then ultimately, they'll take what that score looks like and then present it back to Congress, and then we can work with congressional leadership to adjust it as necessary. Preemption, Robert's going to get into this, but the states are killing us, both from the food additive side and then from the sports nutrition side. How do we fix that? I'll tell you the realities right now. There's a distrust in the FDA, both from Democrats and Republicans. So how do we navigate those waters when it comes to getting the states off our back and federally preempting our products? Because quite frankly speaking, we're getting picked apart. Drug preclusion also plays a part of this. A lot of innovation going on in the industry. How do we protect our IP from the pharmaceutical industries? Things like NMN and NAC are a very good example of that. And then lastly, mandatory product listing. I think from a regulatory standpoint, they're all about transparency right now, but they're also about efficiency, and that's not a avenue I think that the FDA is going to look at, that's not an avenue that Congress is going to look at and say, hey, FDA has been really efficient in how they utilize their authorities and the tools that they have at their disposal. Let's give them an additional regulatory authority. And I can certainly tell you both congressional leadership on the House and Senate side is not supportive of that proposal as well. So that's kind of where we are in terms of the 119th Congress and the state of the industry.
All right, thanks for keying me up on that, Kyle. This is me. I have 50 states and 10 minutes to get through them, so I'm going to move fairly quickly. I'm going to concentrate on a couple of top-level items that are the largest sort of global threat. There are certainly plenty of other state-level issues we can talk about. Quick aside, if you are potentially affected by any of these extended producer responsibility laws, that's a topic we're not planning to get into today, but that is absolutely worth looking into. The implementation in several states is ongoing. As Kyle mentioned, this is a time of great uncertainty and distrust in federal existing authorities. And this has created an opportunity for existing forces that have been operating at the state level to move forward legislation at an expanded rate that creates criticisms of both the general food supply and dietary supplements in specific. The first of these categories, first a roadmap. I'm going to talk about sports nutrition age restriction bills. I'm going to talk about the tidal wave, really, of food additive bans and restrictions that we're seeing this year. I'm going to talk about some of the long-term harms that we can anticipate as these bills make their way through the states. And then I'm going to describe some ways that you can take action to address these as individual actors in this space. First, with regard to the weight loss and muscle building product restriction bills, these all come from a common source, even as they're emerging across the country. This is STRIPED, the Strategic Training Initiative for the Prevention of Eating Disorders, an organization out of Harvard that's well-intentioned. It's supposed to teach students how to be advocates to work against eating disorders. Unfortunately, they also hate our guts. The STRIPED organization is opposed to minor use of dietary supplements, more or less on principle. From conversations I've had with Sydney Bryn Austin, their leader pictured there, she's not a fan of dietary supplements generally. This has had ramifications for how they've approached legislation in the states. Generally speaking, STRIPED advocates for a combination of views that exposure to dietary supplements for weight loss or muscle building cause eating disorders, coupled with broader claims about the fact that dietary supplements are unregulated and unsafe, some frequently pointing to straightforwardly unlawful products like those contaminated with drugs, and using them to create a blend of fear appeals regarding our entire industry. What this means at the state level is that they wind up creating bills that create age restrictions and other restrictions on a very ill-defined scope of dietary supplement products. Not just narrow weight loss or muscle building products, but in some states, bills that have bills cover products that are in the same part of the store as weight loss or muscle building products, or products that are in some way represented in the eyes of a state regulator as being for weight loss or muscle building, or have an ingredient that's used for weight loss or muscle building. The scope is broad and the restrictions are severe. Carding the person who receives a product if it's delivered online, physical access restrictions at stores. Some versions have had warning label requirements where stores must include the kind of labeling that we would usually see around tobacco products. And STRIPED has been pretty effective over the years because they have a network of state advocacy groups on eating disorders that help bring these to state legislative attention. They also have a youth corps of volunteers who can serve as highly sympathetic witnesses in state hearings. It is very unpleasant to have to come up on stage after a member of the youth corps describes how your products cause their eating disorder and only your bill will keep other children in the state safe. Generally, STRIPED has been very strong at introducing bills, and they're very good at media and hearing work through their youth corps, but they've been very weak at moving bills across the finish line. Once something is introduced, they don't always pay as much attention. They've struggled with making revisions to the bills to accommodate practical concerns, and of course, they're not really willing to compromise with the industry. The problem is that this is a time where they don't need to compromise. These are the states where there have been recent bills introduced or active regarding this. A bill passed in New York and has gone into effect, though thankfully there's been no enforcement. There are several bills currently active. The one to really look out for is in Illinois, House Bill 3027. The Consumer Healthcare Products Association got a number of provisions removed from that bill, so it's not as severe. But Illinois is a deep blue state. They didn't even hear opposing witnesses in the first hearing on this bill. It's very likely that this one will move into law unless something dramatic changes. There's a number of other ones that are of concern, but the key point here is that we're going to have to continue to worry about different states implementing different versions of these bills, covering different products, and creating a network of unusual, irregular, and difficult to predict requirements for these products across different states. And even if you're not in the sports nutrition space, there's a decent chance that at least one of these will wind up covering at least some of your products. So, from a narrow part of the market to a much broader one, that's back, food additive bans. These come from a broader array of groups. Plaintiffs' bar affiliates, the Environmental Working Group frequently acts as an advocate. It's heavily aligned with the MAHA movement. Several of the state bills that I'm going to talk about are explicitly AHA-oriented actions. And that's because they're targeting the entire food supply. Dietary supplements are not a focus. So even if RFK mentions the fact that he's an advocate for dietary supplements, these are bills written to address food additives and substances in food generally. And state laws aren't great about distinguishing between dietary supplements and foods. Frequently, there's nothing explicit in the code that distinguishes them. So many of these bills that are only intended to target foods wind up also targeting substances and dietary supplements. There's a particular focus this year, and has been for several years, on certified color additives, your red 3s, your red 40s. This has been a common trend across these, and it's also been a point of concern at the federal level as well when we talk about self-affirmed GRAS. Certified color additives don't go through self-affirmed GRAS. That distinction hasn't always been made. Another focus has been ultra-processed foods under the NOVA classification. Rand mentioned this earlier. This is a not particularly scientific classification, and there is no specific definition for what is an ultra-processed food. Depending upon how it's applied, basically every dietary supplement that isn't a raw herb could wind up falling under that definition. California has introduced legislation where they would try to work up a definition that would apply in law. I'm not sure we want California to do the definition work here. That doesn't tend to go well for anyone in any sector. The thing that makes these bills so frightening, the thing that makes this a crisis, is that this is an unusual moment of cross-aisle appeal. Historically, we've had to worry about crunchy granola liberal states introducing these kinds of bills. But the place where this gets first passed into law is West Virginia. And that state already is going to have a set of certified color additive bans implemented in 2028. The state where we are most likely to see another major bill that's going to affect dietary supplements is Texas, with Senate Bill 25, which passed the Senate unanimously. In Texas, a food additive restriction bill. What planet are we on? So there's a very similar bill in Louisiana. Both of these are a particular concern because they require scary, vaguely Prop 65-esque warning labels on products containing additives that are restricted in other countries. Scary additives like melatonin or color additives or titanium dioxide. The list is very broad, and in some states, it's not very certain. I've got a bunch of blue states here. These are of less concern because a number of these bills are currently only focused on products sold in schools. Again, the protect the children language comes to mind. There are a number of other states I've got in red here where there's a degree of restriction. The particular ingredients appear to be of less interest to the dietary supplement sector, but we should still care about this. The key element of this entire crisis, this entire problem, is that this is a set of existing pressures on food and on dietary supplements that has been allowed to grow gradually through compromise and ignorance over years, and which is now taking advantage of the situation to leap forward. And the harms in the long term can be very severe. First, obviously, if you're directly affected by these bills, you're going to deal with increased costs, both for compliance and for supply chain. If you're having to reformulate to get away from a typical excipient or binder that is suddenly a source of fear for the public in a given state, you're going to be competing with everyone else in the market for that. And in the next year, maybe that one will come under focus. There's a possibility that some states will start building out a regulatory apparatus that will compete with federal system regulations. We really don't want to face a pre-market registration or pre-market approval apparatus or label regimes at the state level when we've been successfully pushing back on this sort of regime at the federal level for so long. There's also concern about reciprocal blowback. Kyle mentioned the possibility of state preemption. That'd be great if we're able to swing it. It's a challenging process, including some of the existing court precedent. But there's also a challenge that in 2 years, in 4 years, an administration can look at a spate of state regulations and come back and say, well, maybe we need to occupy this field by having the same kind of restrictions. Maybe now we need a federal label registration requirement or a federal pre-market approval requirement. That will help us clear up the mess. Now, that's the last thing we want. In the long term, though, the effect of all of this, the MAHA movement, concerns about individual sports nutrition ingredients, is a loss of trust in both the food sector generally, but also the dietary supplement sector specifically. We need to think about how consumers are perceiving chemicals and our products, because this is going to be something that will last for a very long time, even if the science isn't really there. Finally, I make the point that the folks who are promoting these things at a given point 1 year are not going to go away if we compromise with them. We may have to tolerate some laws this year. There are just so many of them. But we should expect that these folks have an incentive to keep pushing on new products, on new ingredients, new restrictions in years to come. This makes getting involved very important. What I think folks should do, first, get involved with a trade association. that should be APA, but if it's not APA, it should be any of the other trade associations. We're all involved with these issues at the state level to some degree. We've got CRN, NPA represented here. UNPA has also been involved. CHPA has been heavily involved as well. APA, specifically on the sports nutrition products, has weekly meetings of folks, members of associations, non-members of association. There's no price of admission, just to try to keep the different trade associations on the same page as we address those bills. We also encourage folks to make direct outreach to legislatures in the states where you're already active. Some of the trade associations are making really strong arguments about the science of these bills, but if you're active in a particular district, in a particular state, your state legislator is really care about the dollars and cents, the practicality of why compliance with these bills doesn't work, doesn't make sense for you. So I encourage outreach on that basis. Frankly, it's late. The best time to have engaged with your state legislature was 10 years ago when these movements were developing. The next best time, though, is right now. And I also encourage you, part of the reason these things have happened is because we've allowed them to fester for a long time. We've allowed unreasonable concerns about certain substances to grow in the marketplace. We haven't challenged them actively enough, both in the sciences and in the courtroom. We need to get more folks involved to understand the risk that this presents structurally to all of us. I'll leave it there. I'm looking forward to the discussion.
I'm exhausted. That was brutal. I don't even know where to start. Let's try to keep our comments brief and try to cover a lot of ground. Kyle, let's start with tariff exclusions. What ingredients were excluded recently? Let's start there.
So we're looking at a number of ingredients that have been excluded. So you're looking at your alphabet vitamins and minerals. You're looking at things like niacin. You're looking at things like creatine. Obviously, there's some confusion over whether something like a botanical is going to be included, but our team's still looking at that, engaging with our membership to, one, figure out if botanicals can be considered excluded from the list, and then two, how do we work with the administration to ultimately get them on the exclusion list.
Thanks, Kyle. And Robert, do you want to add anything about botanicals, specifically what your organization is doing, if anything, in that regard?
We're currently surveying our members regarding which HTS codes for botanicals are of primary concern. We're going to be probably working with several of the other trade associations to have joint communication with the administration and really push for this. And we appreciate this is a challenging moment. Everyone from every industry is asking for tariff exclusions right now. Everyone is wishing they were in Annex 2 on that rulemaking. But at the same time, we think that there's a real dire need, especially in the botanical space, because it's not possible to onshore the growth and development of a number of these botanicals at value or potency at a level that makes them particularly marketing appealing.
You guys getting, just to stick with tariffs for a minute, any feedback from your members in terms of what the effects are going to be in terms of passing costs on to consumers, or effects for ingredient suppliers, just business ramifications?
I mean, I can just jump in really quickly and say that there are clients that are pulling back on other projects because they need to figure out how dealing with tariffs is going to affect their bottom line. So if it was a substantiation project or developing new claims, ingredient innovation, those kind of things are being affected by this. And so putting projects on hold while the dust settles.
Thanks, Rand. Let's pivot over to the FDA. So RFK Jr. says he wants more transparency. They gutted 3,500 employees at FDA, including the entire communications staff. RFK Jr. is supposedly pro-supplements, but he's looking at potentially abolishing, the GRAS pathway and requiring that all new food ingredients are notified to the FDA, which, that would be a sea change for this industry, certainly. Is it fair to say we're getting mixed signals and we don't know what the heck's going on over there? Robert?
Yeah, I think it is. There's a fundamental tension between the administration's focus on cutbacks and increased regulation and scrutiny, as RFK is describing generally. On the self-affirmed GRAS element in particular, I think there's an opportunity for industry education to FDA about the role of the self-affirmed GRAS pathway plays with dietary supplements. The folks that we've worked with at FDA over the years, folks at ODSP, they understand that. They're not skeptical of the self-affirmed GRAS pathway in this space. But some of the other folks who are part of the administration, there's an opportunity to help them understand the vital role that that pathway plays.
And then Kyle, you mentioned, so last year, the FDA's foods program was reorganized. Jim Jones, had initiatives, he had priorities, he's gone. Now we're reading that there's going to be another potential reorganization at the FDA. It's just like more bureaucratic BS. Sorry, that's my opinion. What do you make of it all, Ren? We'll start with you there. What do you make of this, what's going on at FDA, the potential, another reorganization at FDA, loss of staff? What does it mean in terms of enforcement? What does it mean in terms of the industry, active regulation?
Yeah, well, I mean, we do know that recalls are still occurring. I mean, the basic fundamental functions, warning letters are going out. So I think in some respect, we'll see business as usual. I think, priorities may shift. To be honest, I just don't know what that reorganization will look like. So it's sort of hard to tell at this early stage. But I do think some of these themes around transparency and shaking things up should be taken very seriously because, once all of this gets done, what's going to happen 4 years from now? Will someone, or it could be 8 years. We just don't know. But having to dismantle everything and then put it back together again, are we going to be facing this once again? So.
Do we have a handle on Dr. McCary? I mean, for example, a couple of weeks ago, I reported that Senator Durbin met with him about various issues. One was mandatory product listing, Kyle, which you mentioned, and again, we have some competing narratives here. The administration wants more transparency, as you said, but your argument is that the FDA hasn't been exactly efficient in using the tools it has. Do we know, for example, what McCary will think of supplements? Will he be pro-supplements, anti-supplements? Will he continue to back the FDA in its demands for mandatory product listing? Will he be more aligned with RFK on these sweeping initiatives like GRAS, et cetera? Will they go head to head? Will they not agree with these big initiatives?
Well, I think we have to kind of wait and see because he's only been in the chair for maybe a week and a half at this point. I think as it relates to mandatory product listing and what his position is on it, he's going to hear from all the trades on the good, bad, and the ugly. I can tell you from our conversations with Congress right now, though, there's no appetite for it, and it's as simple as that. So if the FDA wants it, that's great. They can want things, but from a congressional standpoint, there's no desire for it outside of Senator Durbin.
Thank you. Robert, going back to the states, I mean, just your presentation was amazing, by the way. I was really just floored by just the amount of activity, so frenzied. Is the industry collectively asleep at the wheel in terms of advocacy? I mean, outside of the trade associations, we talk about this all the time, and I don't know if people join trade associations. It gets boring, actually. But is there more advocacy? Is there more interest from companies that traditionally or historically were not interested in these issues?
So I think I'll use the sports nutrition issue as an example here. That's been going on. We've been having striped bills for, 8-10 years now? APA put together the Access Coalition to try to get all the trade associations together on this only last year after this passed into law in New York. Thankfully, there's been no enforcement there. I do think that there's a problem where large parts of the industry don't recognize. We've had it good for so long at the state level. We haven't recognized the level of hazard that could occur there. And I do think that there's starting to be greater awareness from some parties, but there's a lot of folks in the industry who are still thinking that they can rely on others to sort of do the heavy lifting.
Rand, we're close to New York. You used to work at the Council for Responsible Nutrition. You know they're challenging that law, and it's now under an appeal, Second Circuit. in your view, how important is the outcome of that case in influencing what the other states are going to do moving forward?
And it's my understanding that other states are waiting to see what happens with that case before introducing bills, or I know there's already bills out there, of course, that are pending, but other states are watching for that outcome. And I think if there is a ruling in favor of that law, I think we will see other states feeling empowered to pass their own laws, maybe some that go even further, stretching out to other categories of supplements as well. So I think it's an important one to watch.
Going back to the, was it the AHA the commission that the Trump
AHA?
yeah, the AHA.
Maha-aha.
The Maha-aha, that's a mouthful. Are there going to be stakeholders from the food and supplement industry that are going to be part of that commission? Do we have anybody have anything to share about that?
It's my understanding that several of the folks sort of in RFK's orbit who have been part of the existing more politically oriented MAHA actions are already actors in the supplement industry, though I don't see any of them in the room here necessarily. So there's definitely going to be a voice of industry. The sort of question is which voices wind up getting elevated.
Okay. And Kyle, you mentioned it before, but how good are you feeling about the opportunity to expand access to supplements through this current Congress?
I think this is the best chance that we've had at least since I've been with the organization, and that's going on 6 years now. I can tell you the conversations that we've had with not only congressional leadership, but down dais members as well, is they're looking for opportunities to, quote unquote, be a part of the MAHA movement, and HSA, FSA expansion is right there with it. They understand the importance of dietary supplements, and quite frankly speaking, in terms of HSA, FSA expansion, we're not the only industry that's asking for it. Gyms, for example, are looking at their own piece of legislation, so that way gym equipment can be a part of that exemption. So this is the best chance we have.
That's the good news for sure. Ren, going back to the Federal Trade Commission, so it's real early in the new administration. There's been some, like the Quincy Bioscience case challenging, their claims over the memory supplement. That thing took, 7 years. It's still in litigation. I mean, you got to have a lot of cash to defend something like that. What do you expect out of the FTC in terms of the types of cases they're going to take against this industry? Are they going to be, just more conservative in their approach and not take new cases, try to push the line? What are your thoughts in terms of exposure facing companies?
Yeah, I mean, we haven't seen a really significant case targeting dietary supplements. It's been a while, even with the previous administration. I don't expect that we're going to see a focus on some of the areas that FTC traditionally focused on in terms of supplements, specifically like cognitive claims, weight loss claims. I do think that, at least from what I'm hearing, that this FTC, as I mentioned in my brief presentation, will be focused on more traditional forms of fraud, whether it is deceptive pricing or scams, those kind of things. I mean, obviously there have been cases involving supplements over the years that you could call a scam, but things like perhaps children's online privacy as well, but just more cases of traditional financial fraud, products or services targeting the elderly, targeting children. But I don't think that there's going to be a focus on health-related claims as we might have seen a few administrations ago.
Okay. And so we're just talking about the FTC. Now get into the state AGs. So the states, with all this legislation, right, they're becoming more aware of supplements, not necessarily liking supplements. We just saw in New York last week, one of their consumer branches put out a statement on supplements that wasn't great in terms of the optics. Does anybody here on this panel foresee the state attorneys general in the coming year or two becoming more active again in the space amid growing recognition about food additives, some of these anti-supplement bills, trying to step up enforcement, and also, you know, this perception that the Trump administration is pro-supplements and they're not going to do anything in terms of regulating or enforcing against the commodity?
Yes, for the reasons you just outlined. I think it's logical to see additional state attorneys general action. I would expect that to most likely be focused on cases where the win is relatively straightforward. So I would expect that, and again, this is speculative, to concentrate on things like drug adulterated products, cases where there's a straightforward argument about harm and a straightforward evidence basis. When we get into more complicated issues involving claims and targeted areas like the sports nutrition space for legitimate products, I think that may be shakier ground.
Yeah, I mean, I would agree. I think there's also a lot of other things going on right now that, and I suspect that might capture the attention of AGs, but certainly in cases where it's clear-cut fraud or deception or there's a safety issue, I could see the state AGs stepping up. And don't forget, we also have the California District Attorneys Association. We have had a few clients already been the target of actions by that group, and they have their own task force focused on dietary supplements. So that's another group to watch out for. Over the past 10, 15 years or so, they have been on the lookout for fraudulent claims for supplements, and not just the really egregious ones, you know, that are way out there. Sometimes even more sort of less aggressive types of claims. So there's other players too.
Thank you. I want each of you to spend 45 seconds and wow the crowd with your closing remarks. This is going to be in the Wall Street Journal, I predict. So we'll start with Robert.
This is a time of unprecedented uncertainty and chaos for many reasons. The dietary supplement marketplace is one small corner of that chaos. But by communicating with each other and organizing and taking a consistent approach to how we regulate ourselves, we can become a place of order that will last through this process.
Thank you, Robert. Rend?
Wow, it's really hard to follow that up. That was pretty amazing. Yeah, I mean, just building off of what Robert said, I think now is not the time to be complacent when it comes to self-regulation. Even during a time of uncertainty, the pendulum typically always swings back. So, you know, I don't think it's time to neglect compliance and what you can do to continue to build consumers' trust. I think consumers are getting a lot of mixed messages around products and the benefits or the negative implications. So it's time to really look carefully at the signs that you're using to back your studies, make sure it's sufficient, make sure your products are safe, and not to get complacent with any of those priorities.
And I would just say, while yes, there is uncertainty, it's a great opportunity for us to expand our reach into the states. I'm a former state staffer myself down in Trenton. As a state staffer, it's usually you and one other person, so you have to rely on outside experts to really formulate an opinion on a policy that you're moving. And this is where the importance of being involved in trade associations and, more importantly, advocacy come into play here. We have our fly-in day on May 8th. We're going to be meeting with congressional leaders from across the country to not only educate them on the investment that members are putting into their products, but also to all the policy opportunities that we have to play in for this 119th Congress.
Ladies and gentlemen, thank you for being here. Panelists, thank you for being here. Have a wonderful week.